Well, hello and welcome to News Centre. I am Ashmit Kumar. Now, India today bids farewell to the Indian Penal Code-based criminal law framework. Today, 3 new criminal laws as ratified by the Parliament take effect. This marks a complete overhaul, which in turn has inspired some concerns by members of the legal fraternity. Various bar councils have threatened even agitation against this, what they call our draconian laws. Some have even called for putting the implementation on hold. So what are these concerns? Number one, the earlier regime provided for police custody of 15 days. The language of the new law, however, has given fears that this could extend to 60 to 90 days. Number two, the new laws have vastly increased the power of attachment without the protections and safeguards as provided, for instance, under the PMLA. Number three, sedition is done away with, but it has been replaced with treason. The language is similar. The punishment is even greater. Number four, the new laws punish not only acts of terror, but also the likelihood of committing terror. Number five, adultery has been removed, but the BNS provides for a 2-year jail term for whoever takes or entices another man's wife. And of course, there's the larger issue of institutional preparedness. Are the magistrates, thousands of lawyers, thousands of police personnel at the SHO, SP, SI level, are they geared for this massive change that's coming their way? Now, this, of course, is really an overhaul, or is it an overreach? That's the question that we're trying to put across. We're trying to get the benefit of the insight from legal experts who will be joining us. In fact, speaking of the experts, before we go to them, let's cut across and let's, in fact, listen in to what the Home Minister Amit Shah had to say in defense of the 3 new criminal laws.
पहली बार मॉब लिंचिंग को परिभाषित किया गया है। राजद्रोह को हमने जड़ से समाप्त कर दिया है और देश विरोधी हरकतों के लिए नई धारा लेकर आए हैं। अब भारत की एकता और अखंडता को क्षतिग्रस्त करने के लिए ये कानून अमल में आएगा।
Well, joining me now to take this discussion ahead is former IPS officer Yashovardhan Azad. Also with us are senior advocate Vivek Sood and senior advocate Mr. Sanjoy Ghose. Gentlemen, thank you so much for joining us. Mr. Sood, let me come to you. You're a master of criminal law. The question I want to ask, and this I'll borrow from an interesting conversation I had with Mr. Arvind Dattar this morning. He expressed regret for not being able to join us for this discussion, but he had an interesting insight. He said, broadly, there are a great deal of similarities between the earlier regime and the new regime. Why could we not have done with just simply an amendment? Was an overhaul really required? Was a complete change to the criminal law framework really required? And on doing some research, discovered that about 75 to 80% of the provisions have been copied verbatim. So again, Mr. Dattar's concern, I'm putting across to you, Mr. Sood. Was this overarching change really required? Could we not have done with amendments to the existing regime?
Yes, I would agree with Arvind in this regard, that definitely we could have done with amendments to the 3 laws, because I feel that 90% of the earlier laws, have been repeated, but that may not be the best ground to really challenge these laws. It's a matter of legislative policy, and if the Parliament,
Sure,
if they felt that, the names of the laws should be different and they should at least look more Indianized, so why not? Why not? Why not? So therefore, I feel that definitely we could have done with amendments to the 3 laws. Having said that, there is no harm in having, the new avatars of the 3 old laws in place.
Right, so we have new avatars in place. Let me go to Mr. Sanjoy Ghose. Mr. Ghose, just this morning, we were speaking, you'd put out a tweet saying that courtesy these 3 new laws, after 33 years of passing out of law school, you're made to go back. You're made to get this new book on BNS, the Bharatiya Nyaya Sahita. Give us a sense, this transition that we're seeing, is it being welcomed by the legal fraternity? Because we've seen various bar associations, senior advocates, as well as bar councils expressing concern on what this transition may even look like, even for issues such as fundamental rights and liberty.
You see, so far as the litigants are concerned, it is going to be sufferance. So far as lawyers are concerned, it will be making more money. But, let us be very clear what we are talking about. Just to give you a perspective, just a month back in Delhi, a consumer court said it could not work anymore because there was no toilet and there was no drinking water. Many times, and Mr. Vivek Sood will tell you that in our subordinate courts, the court staff is not there. There's no one to take dictation. The stenographer is not there. Many people will tell you who are in the legal practice that there are so many people who, even after making bail, are so poor that they can't post the bail money. So they are still languishing in prison. So when you are not willing to spend a penny in reforming your judicial infrastructure, when it is creaking with the burden of cases, just to do this cosmetic change and rearrange sections and then sneakily sneak in these draconian provisions like this restructured, as the Home Minister said, up to it's no longer sedition, is desh droho, whatever it is. It is actually a tight slap on the people of India because it is injustice done to them. In fact, the only people who will benefit from this are people who want to misuse the criminal justice system and who want to exploit people.
Fair enough. Let me take that across to Mr. Azad. Mr. Azad, thank you so much for joining us. Concerns being raised in terms of what this transition may look like to the new regime. Now, we're aware that for this framework that we have currently in place, or rather had, was there in effect for many decades. There were various interpretations given by courts, judgments were given that gives clarity on how a law is to be processed. At the ground level, when we have an entirely new framework in place, that must pose a severe challenge for officers at the SP, SHO, SI level to give them clarity on how the law is to be processed. So whether that's a question of police custody or attachment. Has this training been done to build that institutional capacity for this change?
Well, it's a humongous task. And in a country like India, you're dealing with so many states and so many different kind of systems. Obviously, it'll take time. And I don't think, if you realistically ask me, we are not really prepared for it. Because one of the very important points mentioned by Mr. Ghosh earlier is that the entire infrastructure, whether it's of the judicial system or is for the police, is basically unprepared to absorb this. For example, the accent on technology is most welcome in the new criminal laws. It's all right to say that for serious crimes you need the forensic scientists. But for Delhi alone, you'll need 700. What about the entire country? What about you need it for every district, for every serious crime which are taking place? So I think there are many other things also. The way the bill was passed and the 175, suspensions of MPs or they had walked out. So I would have said logically, it should have been extended by another 6 months to give more time for adequate preparation.
Mr. Sood, same question to you, that we have a time where there's a very large body of lawyers that need to gear up. Mr. Ghosh was talking about how this is equivalent to going back to law school. When you, again, the same question, there are precedents that we've had for the last 70 odd years, which give us clarity on how this criminal law is to be processed. When this change comes about, will it not give rise to more interpretational issues, more chaos at the ground level, at the subordinate court level?
I would not agree with my colleagues on the panel because, as we said at the outset, that these are a few amendments here and there. 90% of the law remains the same. And I'm sure we will learn along the way. I don't see any radical changes in the law from the past regime. Some new offenses have been added, some new form of punishment, community service has been added, some punishments have been enhanced. Similarly, there are some changes in the procedure code, the Bharatiya Nagrik Suraksha Sanhita. So these changes are not radical, that we need to train the police force afresh. And let me put this in a lighter vein. The Indian police is yet to learn how to implement the Indian Penal Code of 1860. So, we have a law of 2023. So they will learn both, side by side, 1860 and 2023 law. And learning is a never-ending process. And I've said in my book, Chaff and Grain, on the criminal justice system, that the police in India refuses to reform itself. They refuse to implement the judgments of the Supreme Court, maybe, for example, on the law of arrest in Ashmit Kumar. The whole police system in the country has been colonial, since independence. It's not something that has come into existence now. So I don't see any difficulty in this transition, so-called transition.
Sure.
It's a very minor transition, and we will all learn along the way. Of course, you will have interpretational issues coming up in the court.
Sure.
And so I think criminal lawyers will have to learn, unlearn, relearn a bit here and there. And that's how, law moves to different levels. All in all, I feel that the laws are not badly drafted. They are well drafted. Some of the good provisions have come into existence. Community service as a form of punishment is welcome. Then, now a lot has been said on sedition. I feel that the present law of sedition under Section 150 is far more narrower than 124A. People should read the law between the lines before they make comments. I think it's a better law in place, in my view. And so therefore we will learn, and it will be well absorbed into the criminal justice system in about 6 months to 1 year from now.
Right, Mr. Sood. Mr. Azad, let me bring you back in on the question of police and the preparedness. One aspect I want to highlight, and this is a criticism that has come from various legal experts and legal fraternity, that there are certain provisions within the BNS which provide for expansive powers to the police. So whether that's the question of police custody, under the current framework, the existing framework, we had 15 days. The apprehension is the language will now extend it to 60 to 90 days. There are also vast powers of attachment that are now given to the magistrate court. Interim attachment can be done. There are no protections available like there are under the PMLA. Does that then call into question the larger issue of are we heading towards a police state? Because that's the impression that some of the legal experts are giving us.
I don't think so. I mean, where does the police state idea come from? I mean, even today, the Home Minister made it clear in the Parliament that the actual period of remand is not more than 15 days. And secondly, if you distrust your police, and if you think that your police is third rate or the lawyers are third rate, then how do you begin reforming the criminal justice system? The question is not about the quantum of reform. The question is response. The question is absorption of technology. The question is of having a proper prosecution system. You can have third-rate lawyers, and many of them are, but we have also third-rate prosecutors. The question is, on one side, if you have somebody like Siddharth Luthra, and on this side, you have a very low-grade APP, poor APP, how can he contest that case? We are talking about forensic science for the entire 650 districts in this country. You think it's possible? Even now, the Supreme Court mandated directive of having a video recording or CCTV placed in all the police stations has not been done. You think it's possible to have forensic vehicles in every of those 650 districts? So talking, and giving opinions is fine. Whether police has not been able to implement the IPC of the 19th century, or our lawyers are extending, hearing after hearing on different recuses. Yes, we have a third-rate bureaucracy, a third-rate lawyers, and third-rate police, but we have to work towards a common cause. So here we are pointing out the issues which are involved, and if you replace sedition by treason, how is it that the arbitrary arrests are not going to be made?
Fair enough. Let me take that across to Mr. Ghose. Mr. Ghose, that is, again, one concern that is coming up repeatedly on the question of provisions such as adultery having been removed. But there are provisions that any man seen enticing the wife of any other man is punishable for 2 years. We've seen in case of, even in instances such as sedition being replaced by treason, the punishment is even more severe for the provision for treason under BNS. Is the language, again, and also there are criticism of the use of the phrase national security. What constitutes national security has not been clarified upon in these new legislations. Does the language appear to be vague and open to interpretation, which in turn could lend it to abuse or misuse?
Absolutely. This penal code or whatever they have framed will be a lawyer's delight. Because you see, for example, provisions like deceit, that someone entices someone into a marriage by deceit. And then that is made punishable. What is deceit? What is enticement? And you see, more importantly, let's understand, the core of this. Now, this is a mishmash where everything has been brought together. 75% of the existing law has been continued. Now you have brought in, there is a separate law dealing with terrorism and unlawful activities, UAPA. Now you've brought this into the general penal code. It has been brought in the section of bodily offenses, but then of course terrorism is also to property, right? That's not the point. The point is now a police officer is given the decision or the discretion to decide whether he is going to proceed against this as a normal crime or it'll be treated as a UAPA crime. Now imagine the kind of discretion which can lead to abuse. Also, Ashmit, as you highlighted, the power of forfeiture, the power of attachment of properties. I mean, this is draconian. And, it is very strange. And in a lighter vein, this is supposed to be decolonization. In fact, someone just said, oh, you can't distrust the police. In fact, our colonial masters themselves distrusted the police. And imagine, they could have easily said, no, it is our police and we will trust them. But they made laws which said that confession made to a police is inadmissible. They made laws that if a police arrests someone within 24 hours has to be produced before the magistrate. So the system is not trusting or distrusting police.
Sure.
The system is putting in place checks and balances. These are supposed to be rights. Nagarik Suraksha will also have to balance Nagarik Adhikar. What about the Adhikar or the rights of the citizens? And please understand, and I'm repeatedly saying this, and I'm sure all my co-panelists will agree. At the end of the day, where is the discussion, deliberation, where is the white paper on what is our the criminal justice system? You have put the cart before the horse. First of all, you should have a comprehensive study.
Mr. Ghose, we're running out of time. Mr.
Yes.
Ghose, we're running out of time, so I'll just come to all of our panelists for a closing comment on the way forward. The demand coming in from various bar councils, like the Bar Council of Delhi, is to put it on hold and let suggestions be sent to the Home Ministry, let there be an expert committee. Is this the viable road forward from here? Brief answer here. Putting on hold is the answer, or do we then begin to make peace with the new regime? Which of the two approach is the most sound, more viable approach going forward?
Are you asking me?
Mr. Ghose, that's to you. Yes, Mr. Ghose, that's to you. Closing comments.
So closing comments, very briefly, yes. And as my co-panelist said, this is passed by a parliament where most of the opposition was under suspension. Please don't make this an ego issue. This is an issue of life and liberty of all Indians. Let's rise above ego. Please deliberate, discuss, have a national...
Right, so Mr. Ghose batting for putting it on hold. Mr. Sood, let me come to you for your closing comments. Which of the two approach you think is the more viable one for the Indian criminal law framework?
Yes, my final comment is this. We have the law in force from today, and that Parliament has passed the law. We should now focus on police reforms and reforms of the judiciary, especially at the magistracy level. You may have the best law, but if you don't have good judges, you don't have good prosecutors, you don't have a good legal community, what is good of a good law? If you have a bad law, right, but if the implementation is good, it's all fine. So
so one vote for putting on hold, one vote for moving ahead.
Reforms and judicial reforms.
Sure. One vote for staying put here, the other vote for moving ahead with this new framework. Mr. Azad, you have the final vote here. How would you advise? What would your suggestion be for moving forward with this new criminal law framework?
I would certainly say wider deliberation, wait for another 6 months. The absorption of technology by the police is very important. Similarly, Bar Council's directive to those lawyers who keep on extending hearings again and again. So it's very important now to have a wider deliberation And I totally agree with my co-panelist. A lot deserves to be done in this particular period by achieving a wider consensus.
Right, Mr. Azad. I'd like to thank all of our panelists, Mr. Ghosh, Mr. Sood, Mr. Azad, for joining us. So that's a brief CNBC TV18 poll. Two of our panelists are saying, let there be wider consultations, let the matter be put on hold. Mr. Sood batting vociferously for moving ahead with the new framework that we have currently in place. That's all the time that we have. I'd like to thank our panelists once again. And with that, we're heading into a very short break. But coming up, Ola Electric will launch an IPO at the earliest this year, according to the founder and CEO, Bhavish Aggarwal. He speaks to CNBC TV18 on Ola Electric's path to profitability and growth with or without FAME subsidies. A social conversation with the Ola CEO on the other side.